Tony Buzbee has stated that Jay-Z's motion to dismiss the plaintiff's anonymity in the rape lawsuit was procedurally incorrect, and he described the letters as defamation barely concealed by litigation privilege. A declaration from one of Carter's attorneys mentioned that a woman claimed Buzbee's firm pushed her to file a civil case as an anonymous DOE plaintiff, despite her not initiating the idea of proceeding anonymously and expressing doubts after it was strongly suggested. Ironically, she now wishes to remain anonymous due to fear of retaliation from Buzbee. I understand that this is a battle, but here you have an anonymous source allegedly scared of retaliation, so doesn't Jane Doe deserve the same courtesy against Jay's millions of followers? Doesn't Buzbee deserve to face his accuser just like Jay-Z? Shapiro asserts that this unsolicited information received by Quinn Emanuel substantiates Mr. Carter's right to thoroughly investigate, challenge, and address the unfounded accusations made against him. Buzbee reported that investigators from New York have reached out to many current and former clients of his law firm, with one client even recording such a conversation. He expressed that it is both shocking and unlawful, citing an instance where they allegedly said, "We could get you paid, you could get money right soon, you know, and we gave this kid $1,000 to start yesterday just to get him on the right path." Is Jay-Z scared because attacking the lawyer on a case is crazy? Buzbee posted pictures of the alleged investigators. If people are being paid and clients are being coached, the Bar Association needs to be involved. Buzbee has amassed millions for its clients and Shapiro is a well-known celebrity lawyer.
Honorable Annalisa Torres. United States District Court for the Southern District of New York. Recent letter briefs filed in Jane Doe v. Sean Carter et al., 24 CV 07975 at. Dear Judge Torres, I write on behalf of my client Jane Doe, as well as on the behalf of myself and my firm, in response to several recent improper communications directed to the court by counsel for defendant Sean Carter in the above caption action. On December 8, 2024, my client filed an amended complaint naming Mr. Carter as an additional defendant in this matter. In conjunction with that filing, my firm filed a renewed motion for the plaintiff to proceed anonymously. Rather than merely oppose that motion, as would be expected and proper, defendant Carter filed, the very next day, his own motion to deny anonymity and/or to dismiss under Rule 12(b)(1). It appears defendant Carter made that separate filing, which we believe to be procedurally improper and substantively deficient, to serve as the pretext for defense counsel to submit two letter briefs to the court on December 9 and 10. These letter briefs are, frankly, nothing short of defamation hiding behind the thinnest veneer of litigation privilege. Except for one sentence requesting an expedited hearing, the letter briefs have absolutely nothing to do with the only pending issue before the court, namely, whether my client should be allowed to continue to proceed anonymously. The letter's otherwise irrelevant contentions that the amended complaint's allegations are inflammatory and frivolous, as against counsel's plea that Mr. Carter is entirely innocent, are merely press releases dressed as legal filings. Counsel's December 10, 2024 letter goes much further, and entirely too far, by accusing my firm and I of outright unethical behavior that never happened and which I would never countenance. To be clear, my firm and I categorically deny all of the baseless allegations levied by Mr. Carter and his counsel in these letters. We will respond in due course and due time, through memoranda of law and other appropriate means, to the legal issues at hand as well as the accusations raised by Mr. Carter and his counsel. We also will address verifiable improprieties committed by defense counsel, outright illegal conduct for which we have actual evidence rather than vague hearsay declarations. For the moment, we simply want to timely inform the court that such responses will be forthcoming. Respectfully, Anthony G. Buzbee.
I, Mari Henderson swear, under penalty of perjury, pursuant to 28 U.S.C. 1746 as follows. 1. I am an associate with the law firm of Quinn Emanuel Urquhart and Sullivan, LLP, attorneys for defendant Sean Carter, and I submit this declaration in support of Mr. Carter's motion to deny plaintiff's motion to proceed anonymously. 2. On December 9, 2024, I spoke by telephone with a female adult resident of the state of Texas whose name is known to me. Another adult whose full name is known to me was a witness to the conversation. Point 3. The information contained in this declaration is an accurate summary of the information provided to me by this woman on December 9, 2024, namely that, A. In early October 2024, this woman saw coverage of attorney Anthony Buzbee's press conference regarding allegations of trafficking and abuse by Sean Combs, and submitted a brief outline of trafficking exploitation events via a Buzbee law firm website online submission form. B. The woman spoke with 3 members of Mr. Buzbee's firm and provided details regarding her experiences as a victim of trafficking by celebrities entirely unrelated to Mr. Combs, or Mr. Carter, and she was told they would take on her representation. C. After detailing her experiences to an attorney at Mr. Buzbee's firm, he pressed for a connection to Mr. Combs, asking, "At what point did you meet Diddy?" Even though she made clear that her case was unrelated to Mr. Combs. D. Mr. Buzbee's firm pressed for this woman to pursue a civil case as an anonymous DOE plaintiff, even though she never raised proceeding anonymously as a possibility and questioned doing So after it was heavily suggested to remain doing so, even though she was not interested in remaining anonymous at the time. When the woman brought up wanting to go to law enforcement with her allegations. Members of the Buzbee firm informed her that going to law enforcement was not encouraged. After not hearing from Mr. Buzbee's firm for weeks, during which this woman tried to contact the firm multiple times, she spoke again with a member of the firm who pressed her to confirm false details regarding her experiences as a victim, including that she was drugged, held down, pushed, and physically assaulted. She felt directed and coached by Mr. Buzbee's firm to say that someone held her down and put drugs in her mouth when that was not her experience. She felt forced to lie. When the woman made clear she was unwilling to adapt to the narrative Mr. Buzbee's firm laid out and wanted only to speak her truth, she was dropped as a client and told that Mr. Buzbee's firm was unwilling to represent her any longer. She felt as though once she had expressed that she was not a coachable victim, she was dismissed. This woman shared this information because she felt the conduct by Mr. Buzbee's firm specifically, to encourage lies, discredits those who are legitimate victims. This woman expressed that she fears retaliation from Mr. Buzbee's firm if she shares her true identity or signs her name to a declaration in this case at this time. Point 4. I declare under the penalty of perjury that the foregoing statements are true and correct. Executed in Los Angeles, California on this 10th day of December, 2024.